Hello, my name is Jeanette Burdette. I'm with St. Petersburg College in the class ATE 3515, Legal Ethical Issues in Veterinary Technology, and this is my review of International Law Case Number NSD 1630/2004, and the case is Australian Wool Innovation Limited versus Newkirk. A summary of the case. This case was engaged by the president of PETA in a campaign to boycott the Australian wool industry on the basis of the cruelty incurred by the practice of mulesing and because of its link to the live export industry. The applicants, Australian Wool Innovation, sought to bring action against PETA for hindering trade and conspiring to injure the applicants by unlawful means. The decision was made on Friday, September 16, 2005, at the Federal Court of Australia by Judge Healy J. Just a couple quick definitions. Mulesing is an attempt to reduce the incidence of fly strike by slicing the skin from the buttocks of lambs without anesthetic to produce a scar free of wool, fecal urine stains, and skin wrinkles. Fly strike is a major problem for sheep in the Australian wool industry. When a strike occurs, blowfly eggs laid on the skin of the sheep hatch into larvae, which feed on the sheep's tissue. Fly strike can produce inflammation, general systemic toxemia, and even death. It is estimated that around 3 million sheep a year die as a result of fly strike in Australia. Live export is when animals are exported for slaughter. Just a little bit more information on fly strike. There's different risk factors, including environmental, such as temperature, wind, moisture. Also, the main risk factors are predisposed sheep traits. For instance, dags, which are dried feces left dangling on wool, the wrinkles of the skin of the sheep, followed by urine stain, breech cover, which is the wool covering the buttocks, and wool color, are all predisposed sheep traits. Background on the applicants is the Australian Wool Innovation Limited is a not-for-profit company that invests in research and development and marketing to increase the long-term profitability of Australian wool growers. They represented the Australian wool industry in this case. Just a little bit more information on the wool industry. Australia is actually the world's largest wool producer, accounting for around 20% of global wool productions. The greasy basis, which is the raw material shorn from sheep, whatever is sheared off of the sheep. The value of Australian wool exports in 2015 to 2016 is estimated to be around 2.6 billion. 74% of Australia's wool exports by value were to China in 2015 to 2016. Background on the respondents. PETA, most people are familiar with, is a group referred to People for the Ethical Treatment of Animals. It's the largest animal rights organization in the world. PETA President Ingrid Newkirk represented the group in this case along with other PETA members. Newkirk actually started a Australian wool campaign with PETA. Newkirk contacted Prime Minister Howard in Australia several times over her concerns of mulesing. In a letter dated on August 11, 2004, she actually stated several things. In quotes you'll find she wrote, "We have written to you several times over the last 2 years concerning the extreme suffering of Australian merino sheep as a result of mulesing and live export, and we have yet to receive an even remotely reasonable response. Our members now demand that we move forward on this issue. We are about to launch a worldwide campaign against the Australian merino wool industry, which will continue until your government takes action to end mulesing and live exports. To that end, we will announce an international boycott of Australian wool in October. We're very close to bringing at least 2 more companies that use Australian wool on board, as we have with Abercrombie and Fitch. And of course, we will abandon the campaign if you are willing to pledge to end mulesing and live exports. So in November 2004, Miss Newkirk gave an interview on the Channel 9 60-minute program stating that a substantial purpose of mulesing is to inflict pain on the sheep, and there are currently available to all Australian wool growers viable alternatives to mulesing, and Australian wool growers could immediately cease mulesing. So the Australian Wool Innovations states that these statements by Ms. Newkirk were said to be false and misleading. Therefore, the case originated on November 9, 2004 with an amended statement of claim filed, and then again on June 3rd, 2005, the applicants filed a further amended statement of claim. In reference to the claim, are several points on the Trade Practice Act of 1974. The act was originally, created in 1974 and then compiled and prepared on July 1st, 2010. The object of this act is to enhance the welfare of Australians through the promotion of competition and fair trading and provision for consumer protection. So the causes of action against Ms. Newkirk, or the reason for this case, is the Australian Wool Innovation is claiming that Newkirk was in violation of several parts of the Trade Practice Act, or also referred to as the TPA, including, S52, S45D, S45DB. Also, that Newkirk was involved in conspiracy with other identified persons to commit unlawful acts with the intention of harming the trade of the wool industry. This is just a little bit more in-depth view of the TPA. Some of the claims that they're saying was S52, which is they're claiming that Newkirk was being misleading or having a deceptive conduct. Also, S45D was, creating secondary boycotts for the purpose of causing substantial loss or damage. And then the S45DB, again, in reference to boycotting that can affect trade or commerce. So the final judgment, each contravention of the TPA was analyzed, and Judge Healy J. came to a conclusion based on previous cases that were reviewed. Judge Healy J. ordered that the FASC, or the claim, strike out 2 things: the contravention of S45DB of the TPA, and also strike out Newkirk conspiring to injure the applicants by unlawful means. Her final words on this were, "The respondents substantially failed upon those motions. Such limited success as they have had is trifling and inconsequential or unimportant. In those circumstances, the respective respondents should pay the applicant's cost of those motions." So initially, there were so many claims against Newkirk. However, the case identified, 2 claims that were struck out, and Newkirk was responsible for paying the applicant's cost of those motions. However, AWI did eventually withdraw its lawsuit, and pledged to fast track the development of genetic alternatives to mulesing. Analysis. The significance of this case is huge for the wool industry because it really fast tracked the development to alternatives to mulesing, which in the end is a better treatment for the animals. Just wanted to kind of follow up on, since then there are some new management options. Some strategic chemical use, such as fly boss, is used to spray around the buttocks area. A new clip, as featured on the right, that helps with the wool around the buttocks. Also, intradermal injection that helps with anesthesia as far as if they do clip around that area. And then some just more management on timing of the shearing and the crutching, and then the timing and spread of lambing.